Hello, everyone, and welcome to today's presentation on updated rules and regulations, specifically the prohibited exemption training session that we'll be going through today. This is being presented to you today because RIA Compliance Group wanted to get some educational material out to you as advisors who may or may not have to be dealing with this prohibited exemption rule that's upcoming or in place. And just as a brief introduction of your hosts today, my name is Shaun Knoch. I am owner and operator of Blackwood Investment Group based in Indianapolis, Indiana. And with me on today's call is Kathryn Cimera, who is an attorney at Mallor, Grodner, and an ERISA specialist. So with those brief intros out of the way, we will go ahead and get started with today's educational session around the prohibited exemption training course. And I will turn it over to Kathryn to kick it off.
Thank you, Shaun. So as Shaun said, we're talking today specifically about a concept that the Department of Labor has struggled with for years now. It has introduced rules which have been taken out. Courts have found them to be unlawful, and they continue to try to craft rules dealing with the very issue of when someone is a fiduciary, and specifically regarding when that relationship occurs with respect to investment advice regarding rollovers. So why is the Department of Labor so concerned about this area? The Department of Labor has determined that a large chunk of most people's retirement funds are in their retirement plans, which are sponsored by their employers. And at some point, most employees will have to make a decision regarding rolling over that money. And the Department of Labor feels that this is such an important investment decision for most everyday average participants that they need to step in and provide some protection or let advisors know specifically what regulations they must comply with when providing this type of advice. Specifically, the Department of Labor wants to make certain that rollover advice is done in the best interest of participants. And so the Department of Labor feels that providing this specific guidance can assist with making certain that we have a uniform standard by which advisors must act, and how this action has to comply with ERISA and the prohibited transaction rules, which are set forth in ERISA. So to understand the new guidance, I think it first makes sense to kind of step back and let's look at where this is coming from a historical perspective, and how the new guidance fits in with ERISA itself. Shaun's going to take a few minutes to give us some background information.
So ERISA is really the governing law around, for our topic today, retirement plans. ERISA is the Employee Retirement Income Security Act. It was established in 1974. And really all it is the framework by which fiduciaries must operate when overseeing a retirement plan. And so there are specific fiduciary roles, responsibilities that are in place for those who oversee the plan. So let's go through a few of those today, a handful of those today. The important ones to kind of highlight for today's topic. So let's start off with the duty of loyalty. Duty of loyalty basically just says that fiduciaries must act solely in the interest or best interest of plan participants. That extends to plan beneficiaries as well. And the extension to beneficiaries is really if a participant is deceased and the assets are still in the plan, that beneficiary is now the owner of those assets. So the extension of the duty of loyalty goes to both participants and beneficiaries. There's also a duty to act prudently. Basically, all that means is that they, as the verbiage goes from the legislation, it says ERISA requires fiduciaries to act with the care, skill, prudence, and diligence under the circumstances then prevailing that a prudent person acting in a like capacity, and so on and so forth. Basically, what they're saying is be smart about the decision-making process that goes into the oversight of the plan. If you do not have the ability to act prudently, you can also hire a person to help you or an entity to help you with that decision-making process so that you can act in a prudent manner. You also have a duty to diversify plan assets. And this is kind of a strange one. Basically, the bare minimum is that you have to have 3 different investment viewpoints or investment themes that have different risk and return characteristics associated with them. The easiest way to think about this would be stocks, bonds, and cash. I'm not suggesting that that's all you have in a retirement plan, but that just gives you the basic synopsis of what we're looking for, or what the rules are looking for with respect to having plan assets in place. You're supposed to have a variety of risk and return characteristics in the investment lineup. At a bare minimum, the rule does say that you must have 3 in there. And then the last one that we're going to hit on today is the duty to act in accordance with plan documents. Every plan that's governed by ERISA has a plan document in place that outlines exactly how the plan is to be managed. Any fiduciary who's associated with that plan has the duty to follow that plan document, basically to the letter. And if they do anything outside of that plan document, that's where we can get into some muddy waters. So just to kind of go on to the next phase here with those 4 pieces of information out of the way, who are investment advice fiduciaries? This is going to be specific to obviously the group listening to the call today. If you're providing advice on a plan, we want to outline for you the criteria, how investment advice fiduciaries are being measured. So if you render advice to a plan as to the value of securities or other property, if you do so on a regular basis, pursuant to a mutual understanding, and that the advice will be the primary basis for decision-making purposes, and that the advice will be individualized to the plan. An important note here on item 5, this is interesting wording where it says the advice will be individualized to the plan. Some of you who are operating multiple plans might just have a template fund menu. There's nothing that I'm aware of, and Kathryn, correct me if I'm wrong, that says you can't have a template menu, at least in part, but the individualization to the plan should still be in consideration. So where this might be more specific would be with a qualified default investment alternative. So you might have a template fund lineup of 10 core funds, but your QDIA or qualified default investment alternative, you might want to do a little bit extra due diligence on that to make sure that you have an appropriate QDIA that's in place for the plan.
I think that's exactly right, Shaun. And I think, when you're looking at this 5-part investment advice test, the natural response is, well, how does this apply to rollovers? And why is this something that we need to be concerned about? So for years, that prong 2 on the slide before, talking about on a regular basis, has meant that most rollover advice has been excluded, or most people argue that it didn't fall under what was considered investment advice under ERISA because it wasn't done on a regular basis. But now what we're seeing is that when the Department of Labor published their final regulation with respect to the prohibited transaction exemption, what they stated is in the preamble, they basically redefined or reinterpreted this 5-part investment advice, or in their opinion, they gave some additional information about it to help clarify what that means. So what the DOL is saying now is that rollover advice can actually mark the beginning of an ongoing relationship. So even though that advice specifically may not have been done so on a regular basis, the intent in most circumstances when an investment advisor is providing advice on a rollover is that the advice will continue once that rollover is housed somewhere.
And I'll just chime in here quickly. One important thing, speaking as an advisor, one important thing that advisors should take into consideration about this is that there is a standard of care that's being held out to the advisors with respect to these rollovers, but that standard of care, that fiduciary act, also extends to solicitors as well. So if you are an organization that has solicitor arrangements in place, those solicitor arrangements or those solicitors themselves have to abide by this fiduciary standard of care and are held to the same standards that you as the advisor would be, even though their role ongoing might be limited or non-existent. They're just sending business your way. There is no exception here. Those solicitors are held to that very same standard.
And I think, which we always have to address, is why do we care about this? I mean, why is it important to make sure that we are complying specifically with what the Department of Labor is saying? And that is, as in most cases, if there's a breach, you can be subjected to penalties, damages, even personal liability, and of course, attorney's fees. So it is important to make certain that you are in compliance with what the Department of Labor is setting forth in its regulations. Now, again, kind of going back to give us a little bit of history about how this new rule is applying and how it fits in with what ERISA says, we have both ERISA and the Internal Revenue Code that specifically prohibits certain transactions with a party in interest. And this has always been the case. So we have all of these identified on this slide are considered parties in interest that may be working with a plan or with the participants of a plan. Now, specifically for our interest, we're mostly concerned with these that are identified right here on this slide. You have to make certain that a fiduciary is dealing, it is prohibited if a fiduciary is dealing with the assets of the plan in their own interest or for their own account. You have to make certain that you have someone that is acting on behalf of a party whose interests are adverse to the interest of the plan in any transaction involving the plan. And you also need to make certain that any receipt of consideration for your own account from any party dealing with the plan in connection with a transaction involving the plan assets these are all going to be prohibited. So where this comes into play with respect to a rollover, or where the concern is that when a participant comes to you and they have money in a 401k, they've left the employer, they're now looking to roll over that money, and you're providing them advice as to where to roll it over. If in fact you are getting a financial benefit from that advice, there's a concern that this would be a prohibited transaction.
And I'll piggyback on that comment and extend it a little bit further. Kathryn's absolutely right on that, the prohibited transaction consideration there. But to go a little bit further, many of you are probably serving in a dual role right now, meaning that you are an advisor to a 401k plan or any defined contribution type plan, and you might be serving as the advisor to the owner of the business as well. And so where you can get into muddy waters here is, as Kathryn just alluded to, if you have a business owner and you're a fiduciary to the plan, you're a fiduciary to both. But if you're suggesting to the business owner to pull money out of the plan so that you can manage it directly, that could be a potential problem for you. And you'll want to strongly consider whether or not that would be prudent for you to do, and create some sort of mechanism to gauge, track, monitor the prudence of that type of advice. And one thing to go even deeper on this for you to consider, if you remove assets from a plan, that could potentially impact record keeper pricing, and that record keeper pricing might be impacted negatively, which means your advice to the plan or to the individual in the plan that you're having them roll money out of the plan is in direct conflict with the participants of the plan, because you'd be increasing the fee in the plan with no added benefit to them. So you can get into hot water pretty quickly if you're giving this kind of conflicted information. And so there are potential steps you can take to avoid that, one of which is to just not do it at all and just work with the plan or work with the business owner solely. But in those situations where you have both, you may want to consider how the record keeper structure or TPA structure or advisor structure is in place with regard to fees, who's paying it, and how the participants are benefiting from that arrangement. So just look at it from a bunch of different angles and be aware that this isn't how advice worked 20 years ago, where you could have the business owner pull assets out of the plan and everything is fine. There are implications that go along with that. So proceed with caution and be very conservative in your approach to assessing the validity of a move like that. Kathryn, back to you for the next section.
So let's look specifically at the prohibited transaction exemption, also referred to as 2020-02. This was finalized in December of 2020 under President Trump's administration. And there was a lot of speculation that when the administration changed, that in fact, the rule would be pulled and that it would not be allowed to go into effect. And I think to a lot of people's surprise, it actually did go into effect. It became effective on February 16th, 2021. So that means that it is in place today. Now, the Department of Labor has been a little bit wishy-washy in terms of they have said they're going to provide some additional guidance about this rule, but they have also come out and said this is in place. We're not pulling this rule, which they could have once President Biden got into office. That didn't happen. So we now have to make sure that we are in compliance with the rule, except as we'll explain in a little bit. So what did they do? As I said earlier, in the preamble to the new rule, the Department of Labor provides us with a different understanding of what regular basis means. So what the Department of Labor is saying is that regular basis is when parties agree to check in periodically on the performance of the customer's post-rollover financial product, or when a service provider is holding itself out to the customer as providing such ongoing services. So that second prong is subjective. It's not even necessarily what maybe the advisor meant to do, but it is how the plan participant or the investor actually interpreted the advisor's role. Now, the Department of Labor has specifically stated that if it's a one-time sales transaction, it's not a regular basis. But how do we make that clear? Because as I just said, there can be some subjective understanding on the part of the investor that may be, well, I didn't think that this was a one-time sales transaction. It appeared to me that you were providing me with ongoing advice. So how do we avoid that? If in fact, it is the advisor's intent to be providing a one-time sales transaction, it needs to be clearly stated as such. And best practices means that that's in writing, that somewhere you are going to put a piece of paper with writing in front of the investor and say, we are providing one-time sales transaction. And then of course your practices have to match with what is said in that writing to make it clear that you're not falling within the regular basis of the investment advice test. Department of Labor also clarified what primary basis means. And what they have stated is that advice must be an rather than the primary basis of investment decision. And they've also stated that it has to be reasonably understood that the advice is important to the retirement investor and could determine the outcome of the investor's decision. And this is really important because, as we said in the beginning, the Department of Labor feels strongly that the rollover from someone's employer's 401k plan is likely going to be one of the largest investment decisions that most investors make. It's the biggest chunk of money that they probably have access to, and where it goes and how it's treated becomes of utmost importance to that particular individual investor. What that leads us to understand is that in most cases, rollover advice is always going to be considered important to the investor, making it a primary basis under the rule. So what does this mean? What's the impact of this new interpretation on the 5-part test? What it means is that under most circumstances, investment advisors that are providing rollover advice today are going to trigger the fiduciary obligations. And that is true unless they meet the exemption, which is set forth in the rule. So the exemption allows you, even though providing the rollover advice is going to trigger a fiduciary relationship, and even though it also will likely trigger a prohibited transaction with a party in interest, the Department of Labor has set forth a mechanism by which an advisor can meet an exemption to allow them to still provide this advice. And what they've said is, in order for you to do this, you have to meet these 5 prongs. You have to show you met the impartial conduct standard, you have to have disclosures, you have to have policies and procedures in place. You also have to have an annual retrospective compliance review and self-correction mechanism, and there has to be proper record keeping. So let's dig into these a little bit further. I mean, what is it? What is the impartial conduct standard? Well, you have to be able to show that the advice to roll over, you're doing so meeting the best interest standard. It has to be in the best interest of the investor. Now, does that mean that it has to be the cheapest option? No, it doesn't mean it's the cheapest option, but that is certainly something that you would account for. How much is it going to cost, which obviously falls into that next prong, the reasonable compensation standard. But best interest implies more than just cost. Is it in the best interest for someone to roll over money because, well, we want to have all of our money in one place under one advisor? That's something to consider. So while it may cost us a little more, the feeling that we get that it's all under one person is something that we account for, and is something that it would be considered a reasonable thing to consider. Now, you also have to meet the best execution standard, and you also need to make sure that there are no material misleading statements. And all of this has to be in writing. You have to make certain that you're meeting all of these standards in a written document. Also, in that written document, you need to provide a written acknowledgement of fiduciary status. You need to make certain that you are identifying yourself as a fiduciary in writing. In addition, you have to have a written description of the services and any material conflicts of interest. And the representation has to be accurate and not misleading. And finally, you have to include in there a specific reason why the rollover recommendation is in the best interest of the investor. So what I was just talking about with respect to what that reason may be, it may not be as simple as a cost perspective. There may be some other issues going into making this decision. It may even be as simple as a person has left their job. They are not allowed under that specific 401k plan to keep their money at the employer, and they have no choice but to roll it over. We need to make certain that those reasons are specifically set forth in writing. So from an advisor perspective, we have to create a written document that is going to allow for each transaction to be specifically delineated in writing as to why that advice is taking place. So from a policy and procedure standpoint, investment advisors need to make certain that they have policies and procedures set up to ensure that this process is actually occurring, that we are meeting with the individual, we are putting all of those steps in writing that needs to be placed in writing. We need to make certain that you have policies and procedures that mitigate conflicts of interest. And we're doing so on the standard that a reasonable person is not going to view the advisor's incentive practice to create an incentive for the advisor to place their interests ahead of those of the investor. We have to have policies in place to make it clear that what is occurring is actually for the benefit of the investor, even though it is clear that the advisor is obviously making money off of this transaction. But we have to show that it is a reasonable amount of money and that all of these disclosures have occurred to the investor. And then finally, we need to have a process in place by which you can have an annual retrospective compliance review. And what this means is that the rule specifically states that at the end of the year, you have to have a mechanism by which you can go back and look to make certain that all the standards set forth were actually met. And if in fact you find that there was a problem, you have to have a mechanism by which you can correct whatever was missing. From a record-keeping standpoint, advisors relying on the exemptions have to keep these compliance records for a period of 6 years. So what you need to be thinking about is it's not as simple even as making sure that you have a written agreement in place with people who you're providing rollover advice to. You have to actually have policies and procedures in place and then a mechanism by which at the end of the year, you can go back and make certain that this process has been followed. And then someone from your office in a specific position will have to sign off to say that they conducted this annual review and in fact did not find problems, or if they did, this was the mechanism by which they corrected them.
From an advisor kind of practice management perspective, there are a variety of things that you want to consider. And really, the big deal here is that as you go through the determination process up front for a rollover as to whether or not it is prudent, it's, in my estimation, you can do a couple of things to kind of go through that in a prudent way to make sure that you're not going to run amok of rules and regs. So in my business, I don't do any rollovers any longer, and so this largely doesn't even apply to me. But years ago, when the fiduciary rule was going into play, there was some speculation that plan sponsors would have to actually go and sign off on a document for a rollover, and that the plan sponsors might ultimately be potentially liable for the sign-off of the rollover if the rollover ended up not being in the best interest of the individual. There was speculation at the time. Long story short, that rule is obviously no longer in play, but some of those considerations are manifesting themselves here in terms of how you go about doing this. So at the time, I had developed a very basic template for plan sponsors to kind of go through, and some of those would work well for advisors today and how they can assess whether or not the rollover criteria is being met. So some considerations for you, some things that you should potentially do is develop obviously an SOP for how you're going to tackle this part of your business, if it's even worth it for you to do anymore, and if it is, what are those steps to take. But from a high level, and keep in mind I'm in no position to give you specific advice on this, these are just considerations, but from a high level, any analysis that you do should probably include a fee analysis. What is the fee of the plan? How much are they paying? Are they getting specific advice in the plan? If not, and if they elect to do so, what is the additional charge that comes with that advice? What are the services in the plan versus what you can do in an individual component or IRA? Is there any value add? Is there a way to gauge what your value add is in those services? And anything else that you can really come up with to assess from a holistic perspective if this is really in the best interest of the client, or if it's going to show that it's in the best interest of you, obviously the former being the preferred methodology here. So create some type of spreadsheet, some type of data collection process, whatever it is, whatever that mechanism is, utilize it to look at this rollover from a multitude of angles to determine whether or not it's a viable option for the person you're suggesting do the rollover.
So while this new rule is already in effect, as I said, it was went into effect February 16th of 2021, there is a period of non-enforcement, and the Department of Labor said that it will not pursue prohibited transaction claims against investment advice fiduciaries who are working diligently to get practices in place to meet the standards of the new rule. The Department of Labor said that if the advisors are acting in a manner that would have been exempted under the 2016 best interest contract exemption and principal transaction exemptions, then they will be treated as not having violated this particular rule. And this will continue in place for 1 year. So from February of 2021, advisors are given a year in order to make certain that they are in compliance with the new rule. And as I said in the beginning, there's still a question about whether or not the Department of Labor is going to come out with some either additional guidance or some different interpretations of how this should be interpreted with respect to its application. So it is not something that advisors can ignore. We cannot just pretend that it's going to go away, because that is unlikely to happen. At this point, advisors need to make certain that they are in compliance or working toward compliance, but at the same time, keeping an eye out for the fact that we may see some additional regulations in this area come down. So we appreciate the opportunity to provide this information. We are not providing legal advice in providing you this information. And again, as Shaun said, he's not providing you specific advice. We're just providing you some guidance and education that we hope is helpful to you in becoming compliant with this new rule.
And we understand this is very complicated. This is causing a lot of turmoil in the industry and a lot of confusion, potentially. So I do also want to offer up our contact information if you have any questions. My email, best to get a hold of me, is Shaun, SHAUN, at blackwoodinvestment.com. My phone number is 317-570-4944. Kathryn, what would be the best way for anyone to reach out to you if they have any specific questions as to what they could do about this?
Email is the best, and it's KCIMERA, and that's at lawmg.com.
And with that said, we appreciate your time today. Thank you, everyone, for listening. And we hope you have a good day, and we wish you best of luck in putting together a framework to operate under this prohibited exemption rule.
Thank you.